I've been asked if I can talk a bit about this latest Lucy Letby thing and the issue of privilege, because it seems there's a little bit of misunderstanding, first of all, as to exactly what privilege is, and secondly, why it's suddenly become an issue. So briefly, what's privilege? We're talking about legal privilege here. Okay, as I've talked about many times before, when you get engaged in litigation, you have to do what's called disclosure, it used to be called discovery. And that is where each side has to exchange and allow the other side to inspect or take copies of any material that may be relevant to the case. So that's like emails, letters, accounts, documents, all that sort of thing. The idea being that, it's a cards on the table approach. And you have to offer to supply, just about everything. I mean, you do like a disclosure schedule, each side does one and says, these are the documents we have, these are documents we used to have that are no longer in our control. And also you say, these are documents that we have, but we say we don't have to disclose them because they are privileged in some manner. So where does privilege arise? Well, this arises when you create material in contemplation of litigation. So say, for instance, you either think you might have to bring a claim or you might have to defend a claim. You need to be able to speak very freely and frankly about that. Obviously, first of all, with your lawyers, you need to be completely candid with them. But also that can be between yourselves, within, say, a company. You could say, look, we might be getting sued here. Do we need to actually get some lawyers involved? And you can have a chat about that. And all that documentation is legally privileged. I mean, there is a little bit of a joke among American lawyer circles that people in companies will CC everybody into an email, go CCing in legal for privilege reasons. But the mere fact that you have copied in the legal team doesn't necessarily mean it's privileged. It has to be a discussion about the forthcoming litigation. You can't just say that every time so that you create documents that aren't disclosable. Similarly, you don't actually have to initially claim privilege or say a document is privileged for it to be privileged. It all turns on its own facts. And like I say, the key test is, was all this done in contemplation of the litigation and you were discussing the litigation, whether that's, whether you need to bring it, the merits of the case, your tactics, the evidential issues, all that sort of thing. And that is, that can never be disclosed. You can't be forced to disclose it. However, you can waive privilege. You can say, we are going to allow the other side to see this document, even though we're under no obligation to. And you can actually waive part privilege. It doesn't have to be a whole thing. You've got to be very, very careful, though. And let me just briefly explain about that. It's not uncommon sometimes where you will disclose legal advice if it's positive, if it supports your case. You might send counsel's advice to the other side and say, look, this is what our barrister says about the merits of the case, and we think that's right. You might want to show this to your lawyers, see if they take a view. And you put that document in, but that doesn't waive privilege in all the other documents. But you've also got to be very careful that if you're in a trial and you mention part of a document that is privileged, you say, well, we got told by our lawyers such and such. It's like, okay, now you've done that, we are allowed to see the entire document, not just the bits you are selectively quoting from it. So that's how privilege works. The privilege belongs to the client, not the lawyer. I mean, we see this a lot with the Attorney General will write advice for the government, and people have said, whether go to war or on new tax proposals or something like that, are they lawful? And people say, publish the advice. But the advice belongs to the government, and it's only for the government to waive privilege. Similarly, it's the same for you. Barristers, we can't, of our own back say, well, we waive privilege in this. Although we do actually have conduct of the trial, so it gets a bit technical there. But generally speaking, it's for the client to say, I am happy for you to disclose that, or I'm not happy for you to disclose that. So that's where we come into the Letby thing. Because as you may know, she is now going back to the Criminal Cases Review Commission, because she's already been knocked back on her appeals. But what she's saying is I should be allowed a second appeal. And the basis of that is new evidence. That is a ground for an appeal. You can say, we now have some new evidence that wasn't available at trial. But this is where we get into the controversy here. It's the not available at trial. Like I say, it's a three-part test. First of all, the actual phrasing in the test is, is there a good reason that this material was not produced originally? And that could be because either it just wasn't available at the time, or that with reasonable due diligence you couldn't have found this material. Then the other two limbs of the test are, it must be inherently credible evidence, not just speculative, and also that had this evidence been admitted, it is likely that the jury might have come to a different conclusion. It's not just enough that we've got some new evidence, wasn't available at trial, it's credible. The court can say, yeah, well, it wouldn't have made a difference though. I mean, it's one tiny part of it, and there was like loads of other evidence there, so no, we're not allowing it in. But it all hinges on this, is there a good reason for not doing it at trial? And the problem there is, well, how do you demonstrate why you didn't put it in? You've got to say, well, I mean, if the evidence just wasn't available, you might be able to just put that in without waiving privilege. Oh, this new evidence has come to light, and here's a witness statement from somebody saying, what they've done and why they weren't approached initially. Well, that's fine. But what if you've taken a tactical decision not to call evidence? How hard did you search? And this is where it all comes in, you see, because the argument is, well, yes, we have all this alleged new evidence, but why wasn't it put in at trial? Because, they knew who these experts were. I mean, one of it is all about somebody called Mark Hall, and he had been instructed to act, and then he was disinstructed to act. And we don't know why that was, but that would be contained. Presumably there'll be an attendance note somewhere where counsel have had a conference with their client and with the proposed expert, and for some reason they've decided not to call that person. Well, in the absence of saying, well, this is why we chose not to call this person, then how do you demonstrate there was a good reason for not doing it? Similarly, were any of these 14 new people, were any of them approached? Was there a tactical decision not to call them? Oh, more dogs. So this is the argument, is that in order to succeed on the appeal and demonstrate the good reason for not putting it in, Lucy Letby would have to waive privilege and say, right, I am happy for all the legal advice I received about calling expert witnesses and all the decisions that were made about it, because when we sit down and have conferences, we'll do what we call an attendance note, where we'll make a record of everything. It doesn't have to be verbatim, but we'll keep a record of what was the gist of what was said and why we made certain decisions and what the client's instructions were and things like that. And similarly, there might be correspondence, either letters or emails, where people are discussing whether or not to call these experts. So that is the issue. In order for the Court of Appeal to properly assess whether the first limb of the test, there's a good reason for not putting it in, is satisfied, she's going to have to waive privilege. And so far, she hasn't. So that is the issue. It's whether Lucy Letby is going to waive privilege. But this is for disclosure to the court. And obviously the other side get to see it, the prosecution get to see it. Now, some people have suggested that she hasn't let her new barristers look at this material. Well, there's a couple of points there. While she's now instructing Mark MacDonald as her new junior, Silk, her leading counsel, is still on board. So obviously he would be privy to everything that was discussed, because some people have suggested she's not even telling her new lawyers about what her old lawyers said. Well, obviously, in practice, that just doesn't make sense. First of all, like I say, one of her old lawyers is still on the team. But also, when you instruct new lawyers, you implicitly waive privilege in everything. It's not even waiving privilege, it's actually what we'll call extending privilege. In other words, you've now come on board, here's everything we've been discussing previously with our old lawyers, you are privy to it, and the mere fact you've disclosed it to your new lawyers doesn't waive privilege. Like I say, that's the distinction between waiving privilege and extending privilege. So, Mark MacDonald will have had sight, or should, at least has had the opportunity to have sight of everything that was discussed before. So it's nothing to do with disclosing the previous tactical stuff or decision making to her new barrister. He should already know that. This is purely about, will she waive privilege in order, because like I say, the CCRC, before they remit it, they have to say, well, there's a chance that the Court of Appeal may make a different decision here. But if they go and say, well, we're not going to waive privilege, the CCRC is very likely to say, well, you won't even be able to get past the first limb of the test then. So there's no point as referring it back, because you know, any second appeal would be doomed to failure on those grounds. So I hope that's clarified everything. I've kept it as sort of short and succinct as I can. I mean, I've got other videos on this channel if you search for them that go into more depth about privilege, but I think that's all you need to really know about this. So that is the issue. So there you go. Hope you found that vaguely informative, vaguely useful, and vaguely accurate. Where am I today? Because I know you like that. I'm at a place called St Clement. I've been trying to get out all day because it's beautiful, but I've just been tied up with work. So I just shot here to sort of do this video, because apart from anything else, it's a really nice, relaxing, chill out spot. I'll do my usual, just spinning the camera around so you can see. Come on, spin around, there you go. Now over there, that's interesting, that's a little lane, little track that goes all through the forests and the fields and goes down, follows the river, and it's called Dinas Road, Dinas being the old word for castle. And there's a sort of an interesting thing as to whether or not there used to be a castle down there. I mean, people have spoken about using old stones and building materials to build the houses, and people have suggested that is from the castle, because the idea is it was a proper castle, it wasn't just some sort of like wooden thing. This is St Clement itself. I finally managed to come here at high water. Hopefully, I'm not actually looking at the screen here, but there's a couple of swans doing swanny type things. And I'll spin round again, because there's a really nice church over there that I sometimes film at. If you search on this channel for hearsay, I did a video about hearsay outside that church. I mean, I don't expect you to sort of watch the video or anything, but I did it. There's a really nice old standing stone there that's been repurposed. We're not sure how old it is, but it's interesting in that it's got Latin writing on it, but it's also got Ogham down the sides. So the idea is that might be a standing stone dating back 4,000 years that over the intervening millennia, people have actually just adapted and adopted. So there you go.